Hello guys, my name is Aman Ahmed. I'm a legal intern at Lexicon Company, and today, and I am from Faculty of Law, Delhi University, pursuing 3 years law. The topic of my today's review is the concept of jury system and how it was impacted after the Nanavati's case, the significance of Nanavati's case in India. So the first we should establish what is a jury system. So a jury system, as discussed. By a group of people specialized in the field of law and also who are interested with the task to produce a decision on the submission of relevant facts and evidences in a case trial. In this system, it is the judge who explains to the jury about the applicable laws in a particular case, and with that, the jury has to apply them in the evidence and determine a verdict. So, a criminal trial always include 12 jurors, which the law allowed up to 2 jurors to be excused as the trial proceeded. So, however, a judge and jury cannot be held as a similar. So, a judge is an individual who is tasked with presiding over a case proceeding, while a jury is a group of people who have sworn to give a verdict to a case as it is given to them by the court. A trial by jury is preferred mostly in the US, as the attorneys can use emotional arguments which may turn the case in this favor. So, ironically, there is also a reason behind the decline of jury system worldwide, including the US, as the juries are often subject to biasness and partiality in comparison to impartial judges. So now the Nanavati's case. The Nanavati's case, also known as KM Nanavati versus State of Maharashtra, it is a 1962 case, is considered one of the most important cases in whole of Indian legal history. So the case also officially marks the end of jury trials in India. However, the Nanavati case is not the last one which was heard by jury. The last case to be heard by jury in India is was another case, but Nanavati is not the last case. But it started the uh, it is considered as one of the last cases for a jury system in India. So returning to this case, uh, Parvi, a senior commanding naval officer, was charged with the murder of Prem Ahuja, his wife's lover. So the detailed fact are that the KM in the case of Nanavati was he was a 1959 Indian court case where the accused was charged with the murder of his wife's lover Prem Ahuja. So the incident attracted a lot of media coverage and many books were written based on this incident also. So it had public sentiment attached to this case also. So initially, Nanavati was declared not guilty by a jury, but the verdict was dismissed by a Bombay High Court and the matter was retried as a bench trial. So the accused Nanavati was second in command of the Indian naval ship Mysore. He was married to Sylvia and had 3 children also. So Prem Ahuja was an automobile businessman and was also an Agni, who in turn was a friend of Nanavati. So there he introduced Ahuja to the Nanavatis, and a friendship between them was formed. So the accused, being in naval service, had to leave from Bombay frequently for work. Thus he had to leave his family beyond also. For this reason, Sylvia had a relationship with her lover. Uh, with Prem Ahuja, which slowly turned into a good friendship later on. So, however, this friendship led to an illicit relationship between the two, and for this, Sylvia Nanavati felt extremely guilty. As a result, she admitted about her illicit relationship with her husband when her husband came back from the expedition, which got him engaged, leading to the murder of Ahuja. So, for this, Nanavati went to the ship and took a semi-automatic revolver gun. He also signed it into the diary along with 6 cartridges from the ship's store on a false pretext. So later he went to Ahuja's house, entered his bedroom, and shot him dead. So after conducting such act, he later turned himself into the police and was arrested under Section 302 of Indian Penal Code. So this case was primarily to be heard in the session court. So, so the judgment was, the court in this case held that the murder was a well processed and thoughtful one, and it was not under a fit of rage. He planned the murder. He went back to the ship. He took out the revolver, signed the form also, and it was also alleged that he took his wife and children to the cinema theater before he committed this murder. So there was a long process behind the actual murder, which the court said, which certainly did not attract exception 1 of section 300 of IPC, as the accused also failed to bring the case under general exception by adducing evidences. For this, the court found the accused guilty under section 302 of IPC and sentenced him to imprisonment for life. The majority of the people know that Navati's case is his last case that was conducted by jury trial because of the media attention it got, but the real last time to be conducted by jury was held at Calcutta High Court in 1973. This case was also a common, and I will make a dedicated video regarding it in the future. So thank you. Before ending the video, I want to say that please remember the video does not violate any guidelines of Bar Council of India and does not solicit or promote any of the advertisement, and sole purpose of this video is educational. And please subscribe to the channel if you haven't already to see more of this content in future, and I'll be coming up with the next video very soon. Thank you.